Every day, citizens around the country are faced with new dilemmas. Dilemmas that affect them profoundly. Whether it's injustice, discrimination, falling through the cracks, scandals and cronyism, balances of power, ethics, religious freedoms, state versus citizens, and unfunded mandates, and the list goes on and on and on. Welcome to Speak Up. It's directed at those who have fallen through the cracks, and it gives them a voice. It's your turn to speak up, to stand up and fight back. Thank you for joining us for Speak Up. I'm Representative Kevin Avard. Today's show is about a part of our Constitution, the New Hampshire part of the Constitution. Second part, Article 73A, which was adopted in 1978, has a lot of controversy surrounding it. We have a special panel today to talk about those very controversies, including the chairman to the Redress of Grievance Committee. We have Representative Paul Mirski and Dan Itse, Representative Itse, and Representative Sorg to give their professional opinion on the history, the ins and outs of this very controversial amendment to our Constitution. It's very important for the public to understand the gravity of this amendment. And CACR 26, which will be it'll be before the public and on the ballot. I highly recommend that if you have the time, take time to listen to what these gentlemen have to say. And as New Hampshire citizens, I'm asking you, take the authority back and vote for CACR 26. It's imperative that your voice be heard. Welcome to another edition of Speak Up. I'm Representative Kevin Avard, your host. I have the distinguished honor to represent or introduce some representatives here from the New Hampshire House, starting with Representative Mirski, Paul Mirski, Representative Dan Itse, Representative Paul Ingbretson, and Representative Gregory Sorg. Each one of these, welcome gentlemen.
Thank you for having us.
All right. Well, we have a particular topic to talk about today, and it's a very interesting topic to me, and it has to do with the second part, Article 73A. On a number of occasions where some of my guests have come before our, have come on this show, we've discussed 73A at length, and I'm glad I brought some experts here to discuss it. And Representative Ingbretson, not Ingbretson, Itse, I know you.
Way too well.
You're way too well. What committee, let me just start off, what committee do you start off with, Representative Mirski?
Are you going to start off with me?
Yeah, I just want to talk about the committee that you serve on here at the Capitol.
I'm chair of a committee called Legislative Administration. It's kind of a catch-all committee. Bills come to us, they don't know where to put them otherwise. And I've also been chair of the special committee on redistricting.
Representative Itse.
I am chairman of the Committee on Constitutional Review and Statutory Recodification. It's a new committee this term. It has been on about a 16-year hiatus. And its purpose is to the best of our ability, ensure that the bills that we pass on to the Senate are indeed within the confines of the Constitution. And then the 1,000-pound gorilla in the room is the second part, recodification, which is to get rid of, thin out our laws and get rid of those which are no longer effective or enforceable.
Very interesting. And now, speaking of hiatus, apparently the committee that you sit on and chair, Representative Ingbretson, has been on hiatus for about 100 years.
It's been on hiatus forever. We've never had one, as far as we know. We've had redress of grievances from the very beginning, but an actual committee we can find no evidence of. We just find that we have done it, and we've done it through ad hoc committees, and we've done it through sending the complaints, the grievances, right straight to a committee on the subject. But that's it. So we are we're making history. I have plates on my car that I think have never been on any car before. Redress of grievances.
Well, welcome. And Representative Sorg.
I'm Vice Chairman of the Constitutional Review and Statutory Recodification Committee, and until fairly recently, I was Vice Chair of the Judiciary Committee in the House.
And you are also on the Redress of Grievance Committee as a permanent guest, or?
I've been a guest frequently, but not permanently.
Right.
Depends upon how busy the Constitutional Review Committee has been.
Right.
He's a lawyer, and we really need his help. He's a good writer, but he's also able to just get into law and find those places where we need help, as you know.
Right, absolutely.
And also just to write clearly and effectively when we're putting the reports together.
Right.
It's been enormous help. We've got to have him.
Well,
He stole them from me.
from what I understand, also, Representative Ingbretson, just on the side, I understand you're an artist. And I just
Yes,
wanted to put that out. I wanted to put that out there for the public. If you're ever interested in looking at some fantastic art, look them up. So I want to start off with you, Representative Itse, if you don't mind. Recently, you folks actually had a panel at the St. Anselm, and you were talking about this particular topic. That's why I invited you onto the show. I'm very intrigued about the history, about the constitutionality. And I would like to start off with you about some comments on 73A.
Well, what I really spoke on at that meeting was the position of the people relative to their Constitution, relative to their government. Part of the problem we have in our society, I guess there's a few fundamentals, but what I really see is that there has been a disconnect between the actual design of our government per the Constitution and the way it operates now. We operate in society more as subjects than as citizens. We've lost the real idea that those of us in Concord are not really the government. We are not the source of power. The people in Concord are not the sovereigns of the state. It's the people individually that are the sovereigns of the state, and they have delegated some of that sovereign power to the government of New Hampshire. For the government of New Hampshire would be probably a better way to put it. Our Article 8 states very eloquently that all power residing originally in and being derived from the people, all the officers and representatives of government are their agents and substitutes, and therefore are at all times accountable to them. I go up to Concord. I'm elected from Fremont. I represent Epping and Fremont. But when I'm in Concord, I am the embodiment of the citizens of those towns in Concord in the makings of the laws by which their lives will be governed. I'm their voice, I am their image in government. I think it's very instructive when you look at what was originally the last article of our Constitution, which actually contains a lot of really wonderful ideas on the relationship of the people to their government. But for the moment, the last sentence talks about the lawgivers and magistrates and the administration of government. Those of us up in Concord, we're not the government. We're the administrators of government on behalf of the people. It's the people who really comprise the fundamental power of government. Government has no power that the people themselves don't originally have. So just take the idea of food stamps. Do you have the power to go to your neighbor, stick a gun in his belly, and demand that he pay for your children's food?
Absolutely not.
How then can you delegate that power to government? If you don't have it, you can't delegate it.
Right.
Government ought not be exercising any power that that any of us can't exercise individually. That's why, for instance, people don't realize police power. Any of us has the power to make a citizen's arrest and bring that person to account before the judiciary. Now, we do hire a number of individuals to act as police on our behalf. But we actually have that power as individuals. We choose to aggregate it in various ways. We as individuals have the power to require justice. We choose to aggregate that power in a judiciary. But the judiciary has no power that doesn't originally belong to each of us individually. And that's an important concept that's been lost. Article 38 is magnificent, and it's instructive that when our founders wrote that Constitution, it was originally the last article, the capstone. And it requires, okay, first to define a word, recur. Recur means to read, study, and discuss. So it says, a frequent recurrence to the fundamental principles of the Constitution and a constant adherence to justice, moderation, temperance, industry, and frugality are indispensably necessary to the preservation of liberty and good government. Not a good idea, not just what people should do. It's indispensably necessary. So all the people of New Hampshire should be reading, studying, discussing. It should be dinner table discussion, coffee table discussion. What does the Constitution mean? How are the representatives in government adhering to it? The next phrase is really rather a voter's guide. It instructs the people how to select individuals to represent them in Concord. It says, the people ought, and ought is the moral imperative, the people ought therefore to have a particular regard to those principles in the choice of their officers and representatives. So when the people are looking for candidates to represent them in Concord, their first question should be, well, what do you think of that Article 8? Do you understand it? Do you know what Article 7 says, which is state sovereignty, by the way? Can the candidates display a working knowledge? Do they even know that there's two parts? What are the names of the two parts? I mean, that should be a real basic question.
Do you think that this should be a required study in the public schools?
Absolutely. I mean,
It's a loaded question.
It is a loaded question. You just throw me back to Part 1, Article 6. In its original rendition, it said, I got to look at it to get the verbiage right.
By the way, this yellow book is the Constitution in your hands.
This is the Constitution of New Hampshire. This is actually an edition printed by Howard Kaufman, a resident of Nashua. He printed it up as part of his campaign for the State House in 2010. And he now makes them available. It says, as morality and piety, rightly grounded on what our founders called evangelical principles, will give the best and greatest security to government and will lay in the hearts of men the strongest obligations to do subjection. And as the knowledge of these is most likely to be propagated through society, therefore, and then there was a disastrous amendment in 1966, it really mucked things up, but it used to say, therefore, the people may empower and do hereby empower the legislature to authorize from time to time schools for the public instruction of the deity in the several towns, parishes, bodies, corporate and religious. So, a body corporate is a town, basically, and a corporation. So that was an authorization to the legislature to create public education. Evangelical principles, as best as I've been able to determine, really meant bottom-up government, church and civil. So the original purpose of public education was to teach the principles of the Constitution so that the people would know when, as I lovingly refer to us, the goobers in government were doing something outside of their restraint. One thing that people should remember is the purpose of a Constitution is to make government inconvenient. It's to make it difficult for us. If there's no Constitution, we can do anything we darn well please. There's no restraint. A judge can do whatever he wants, and it becomes remarkably simple for those of us in government. With a Constitution, it shackles us down to a set pro forma by which we have to act. And then the last sentence in Article 38 went on to describe, and that they is the people, and they have a right to require of their lawgivers and magistrates, which includes the judges, their magistrates, an exact and constant observance of them, those principles, in the formation and execution of the laws necessary for the good administration of government. So we are the administrators.
We or the courts?
All of us.
Okay.
The legislators, the executive department, we have different functions, but we are all administrators of government on behalf of the people. We are the officers and representatives. All the judges have gubernatorial commissions. They are officers of the state.
So the people basically are the real power, not the government.
Correct.
The people have the authority to tell the government what to do, not the opposite way around.
And so, when, and what they do is they deputize us. A deputy is somebody who exercises all the power of somebody in absence, in their absence. They deputize us to make laws on their behalf that they, in theory, all agree to. They deputize the executive department to execute those laws. They deputize the judiciary to fairly adjudicate those laws. And that brings us to where we are today, which is Article 10. And it's commonly called, it's titled in our Constitution, Right of Revolution. There is no actual title. And if there were truly a title, it would probably be better phrased a duty to revolution. But it says, government being instituted for the common benefit, protection, and security of the whole community, and not for the interest or emolument of any one man, family, class of men, which means you can't put one community, for instance, above another community. Therefore, whenever the ends of government are perverted and the public liberty manifestly endangered, that's that liberty we're trying to preserve, and all the means of redress are ineffectual, the people may, and of a right ought, and that's that moral imperative, that's why it's a duty, to reform the old or establish a new government. The doctrine of non-resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. Now, if you think about that, how do we reform the government? Well, we do it in the first instance by voting, by selecting individuals like myself and all four of you gentlemen who choose to adhere as closely as they understand the Constitution to go and represent the people up in Concord. So that's the first way you reform. You find people up in Concord aren't doing your will, you send different people up to Concord. The second instance is if there is some article of the Constitution that, by reason of time or interpretation, has been perverted or become ineffectual, the people, it's their power. They always have the right, the indefeasible right, to amend that Constitution so that the government serves their purposes and not some other purpose. And that's really what we're talking about here. And then in the third instance, if the government, in all instances, refuses to obey the Constitution, then you scrub it and start over. But that's an obligation. It's an obligation of the people to understand what is happening in their government so that they know when those of us in Concord are not doing their will.
So tell us a little bit about the legislator. We make the laws.
Legislature. Yes.
Legislature. I'm a little tongue-tied today. What does the judiciary do?
Well, the judiciary, Hamilton described it as the weakest branch of government because all it does is adjudicate the laws, and it doesn't actually have any power over any other branches. Its job is to take the laws as promulgated by the legislature and the individuals who are being held accountable under those laws by the executive and determine how that law stands relative to the act or alleged act and determine how that law stands relative to the Constitution.
Now, let me ask you this. Should judges be able to make law?
There are a number of articles in our Constitution, in Part 1 and in Part 2, that give that power exclusively to the legislature. Part 1, Article 12 says, nor are the inhabitants of this state accountable to any laws other than those to which they or their representative body,
So the answer is no.
No, the answer is no, have given their consent. Article 29 says that no law ought to be suspended or executed but by the legislature to be exercised under those particular circumstances as the particular cases as only the legislature shall expressly provide for. That doesn't give any latitude to the judiciary to create or to nullify a law. It says they can't.
But this begs a question, if you don't mind, and then we're going to take a break after
Yeah.
you answer this one question. Of course, recently we're talking about 73A, and second part, it was adopted in 1978. The last line to that bill says that such rules, so promulgated, shall have the effect of law. In other words, from the way I read that article, it says that the Supreme Court Justice can make a rule, administrative rules, which have the effect of law.
And that puts Article 73A into substantial conflict and inconsistency with other provisions of the Constitution. Part 2, Article 2 says that we are the legislature is the supreme legislative body in the state. Well, if we're supreme, how can any rule be equal to that? Article 37 says that the three branches of government, to wit, the legislative, executive, and judicial, and they're listed in that order for a reason, ought to be as separate and independent from each other as the nature of free government will admit, or is consistent with that chain of connection that binds the whole Constitution in one indissoluble fabric of unity and amity, which says that if you're going to figure out how the three branches of government relate to each other, who has power over whom, you have to read the whole thing and figure out who has power over whom.
Right.
Yeah. I do a diagram. I teach the Constitution in public schools sometimes. I have a diagram that I set up for fourth graders that just says, this branch has power over this branch, and so when you diagram that all out, and I won't try to do it right now live, but you then at the end you just count up which body has the most arrows coming out of it,
Right.
and that's the most powerful branch. And the low man on the totem pole is the judiciary. That's why Hamilton considered it the least powerful branch.
And on that note, we're going to be right back with Representative Sorg. And we're back with Speak Up with Representative Sorg. We're going to talk a little bit about basically reining in the courts, where they stand today, and you have an interest in the powers of the courts as they stand now. Could you talk a little bit about that?
Yes, that's really what got me interested in state government some 18 years ago when the Claremont decision first came out. You asked Representative Itse a few moments ago, does the court make law? And in a limited sense, it does, in a constitutional fashion anyway. When it rules on a case, it's decided the law of that particular case. But what the courts have come to do is to make decisions that they apply universally. Decisions made between two litigants that they'll apply to everyone, whether they're litigants to the case or not, that will stand as precedents, that will last through time, and that severely limit our ability as the people's representatives to change the law to keep up with the time. We're constantly fighting with the court, which claims the authority to make decisions of a constitutional magnitude that are binding on the legislature, which essentially forces us to legislate by supermajority in order to get a constitutional amendment before the people, and then 2/3 of them have to vote in favor of it in order to override the court. So we're in a position where any 3 of 5 Supreme Court justices can undo the work of a 400-member House, a 24-member Senate, and the governor. And that's certainly not in keeping with the role of the judiciary as it was intended by the founders. Yeah, I've made it kind of my mission in the legislature to reset the whole question of the people's understanding of what the proper role of the courts is in our system. The good deal of authority the courts have exercised has become so common and so accepted that people assume that that's just the way it is. But it's not the way it is. It's the way the courts have made us think it is. At St. Anselm's a couple weeks ago, I took the discussion back to the roots of what's known as the independent judiciary, which, as usual, took place in England. Our English forebears did a good deal of the heavy lifting for us to provide the basis for our constitutions. And one of the last things they did in the 17th century, as the 17th century was ending and the 18th century was beginning, very appropriately enough, they created the institution of the independent judiciary. And all the independent judiciary consists of is that judges will serve during good behavior, and their decisions will be binding upon the parties before them and will be enforced. The purpose of giving them tenure during good behavior was to protect them from influence, from political influence emanating from the parliament and the king. But that can work both ways, and Parliament understood that. How do you protect Parliament and the king? If you're going to make the judiciary independent of the people, how do you protect the Parliament and the king from political influence emanating from the courts? Well, in England, they had two effective ways of doing it. One of them was that a decision of any court in England, even of constitutional magnitude, can be overturned for future cases by the Parliament just by an ordinary act of legislation. That's number one. Number two is that courts, when they issue decisions of that sort, they also have written opinions which show how they arrived at their reasoning. And those are examined to determine whether they truly represent a dispassionate, impartial exposition of what the Constitution provides, or whether it's politically motivated. In other words, whether the judges themselves have an agenda that they're furthering through their opinions. Put colloquially, a decision has to pass the laugh test. Now, in this country, we've forgotten those two things. When the Constitution for the United States was proposed for the people, Alexander Hamilton wrote the Federalist number 78, the thesis of which was that don't worry about Congress exceeding its authorities because we can depend upon the federal judiciary to keep them in line, because if they pass a law that exceeds their authority, the federal judiciary will declare it unconstitutional. Hamilton was posing as a strict constructionist in writing the Federalist 78. Seizing upon that, some 15 years later, Chief Justice John Marshall wrote in Marbury versus Madison that an act of Congress which is contrary to the Constitution is automatically void. And he set up the courts as the Supreme Court as the entity that makes that determination. So the Congress effectively got frozen out of the process, except unless they can amend the Constitution through the supermajorities. Now, New Hampshire had its counterpart to Marbury versus Madison. It's a case from 1818 known as Merrill versus Sherburne, in which the court, invoking the Federal 78 and Marbury versus Madison, basically claimed the same power for the highest court in this state. What has happened is, what has happened now is since we have written constitutions, whereas England has constitutions that has come about through legislation over the centuries, some of which is considered fundamental, some not, but any of which can be changed through ordinary legislation. We have fixed constitutions that can only be changed through supermajority votes to amend them. And that has given the courts, when they claim authority as the final authority to interpret them, that has made it very difficult for the people's will to prevail. And we've also gotten out of the habit of examining their decisions. We just look at the bottom line. What did they decide? Okay, we have to be bound by that. We don't look at the decisions to see whether they're politically motivated, and some of them in recent years have been blatantly politically motivated, but we're told that we're not allowed to look at that.
What can the legislator do about that? Supposing half of the body says, hey, listen, this doesn't sound right. Do you need a supermajority to challenge the court?
You shouldn't have to. What we should be able to do, in my view, is to just pass a resolution declaring that the court has decided this. For these reasons, we think the court is wrong, and therefore the law shall be this. Period. Because we're the people's representatives. We're the ones closest to the people, and as Representative Itse told us, that the people are sovereign. So we should prevail over the court. It's been a very hard sell, though, because the court has been very effective over the last 2 centuries since Marbury versus Madison in convincing us that the court has authority to interpret the Constitution with a final binding effect upon the legislative branches, which, if true, makes the judiciary the true supreme branch of government and constitutes the judiciary as an oligarchy. We have the net effect of our revolution, all our experience, is to have traded rule by the king and the Privy Council for rule by an oligarchy of judges.
Right. And try to get a judge to change a rule. I'm just thinking of if an individual wants to approach a judge, where's your representation there? You have none.
That's another problem. The judges attach more importance to their own precedents than they do to the Constitution. So if years later they know that the precedent was wrong, it was bad, their own desire to maintain their mystique of omniscience and infallibility prevents them from admitting the mistake, so that the decision from 20 years ago, which people today may have had nothing to do with,
right,
we're stuck with it.
That begs a question, if you don't mind me asking, regarding 73A, supposing, based on something you just said too, supposing the legislature makes a law that is contrary to the Constitution, but the courts like that law and say, yeah, it's lawful because it works in their favor.
That's right.
Shouldn't the courts be challenging that law? In other words, they'll only challenge laws that take away their power, not give them power.
Yes, it is a curious thing. The phenomenon was noticed 200 years ago by, among others, Thomas Jefferson, that little by little the courts extend their area of authority. That when you trust one branch of government with the authority to determine the allocation of power among the three branches of the government, guess which branch is going to advance and which ones are going to be retreating? And that's exactly what's happened. The judiciary keeps getting more and more powerful. The representative branches of government become less powerful because the representative branches have pretty much conceded to the claim of the court to have authority to determine the allocation of authority among all the branches.
So talk about judicial review, if you can. How do we go about reining these people in?
Well, we have to just recognize what our true authority is. I've always felt that all we would need to do is just once make a firm declaration that this is what the court has said, this is what we believe the law is, therefore this is what the law shall be. And we've done that in the House a couple of times. We passed HCR 14 in 2003, which basically declared that the Claremont school funding decisions were beyond the court's authority. They were policy decisions, and the legislative branch is the policy-making branch of the government, and they were therefore null and void. The Senate just killed that, and so.
Now today we're dealing with CACR 12, is it? Is that
12 is the one that is aimed at reversing Claremont through a constitutional amendment, which the people sitting at this table don't believe we should have to do. But
well, that's the point. I mean, we have to go through such rigorous geriatrics, just to gerrymandering or whatever, just to get the people's will done because of the power of the courts.
That's right, and we shouldn't forget too that the court's decision was based upon Article 83, in which the language saying it's the duty of the legislators to cherish the interests of education. That's only one out of, I think I counted 16 aspirational goals that are in Article 83. So if the court can declare cherishing the interests of education to be a fundamental right that we have to support at the state level, what's next? And if we just accede to what they have done, we're opening ourselves to whatever fad comes to the fancy of any three judges in the future, and we have to keep stamping out these fires one by one through constitutional amendments? I don't think so.
Well, how can the concept of judicial review be successful then? I guess that's one of the questions that I have. We just have to make a broad statement saying through the House that this is where we stand and shut up? What do we do?
Well, we certainly need the courage of our forefathers who had no problem standing up to overreaching judiciaries. We have become basically civically lazy, both in the state, both among the people and among the people's representatives. I've heard it said in the ante rooms of the legislature that people have actually said, legislators actually said, it's none of our business to
I've heard
view the
this.
constitutionality. That's the court's job. We just do what the court says.
Right.
I heard another time a representative saying she was serious about this. She said, if we don't pass the education funding the way the court says we should, will we be arrested?
Oh my gosh.
Yes.
I expected she thought that then Chief Justice Broderick was going to walk in with the manacles and haul her off to prison for not passing the laws the court says we have to pass. It's all so nonsensical and ridiculous, but it's been the prevailing wisdom for so long that people actually believe it.
Wow.
But as Hamilton said in '78, and as Representative Itse stated a while ago, the court has no authority. A judiciary has no authority other than to make decisions. It makes judgments, and it issues orders. But even those it can't do unless the legislature votes funds to build the courthouse and to provide personnel, and the executive branch then goes out and hires those people and builds those courthouses. It can't do anything without the cooperation of the other two branches. But the court itself has said, I believe, that every branch has the authority to do what is necessary to protect itself. And that's a claim on the court's part that if we don't appropriate the money it thinks it needs, it could just order it to be collected for it. Or if we don't build the courthouses and provide the facilities and the personnel they feel they need, they can just order it done. I think they really believe that. There is such a pervasive ignorance among the people generally, and even among the judges themselves, that they think they can do pretty much whatever they want.
It's a pretty powerful statement.
It's very disturbing to me.
Right. Well, we're going to take another break here, and we'll be right back with Representative Mirski. And we're back with Speak Up, and we're going to be talking with Representative Mirski. Representative, you have the floor.
Judiciary, the legislature. I like to tell people that when I was elected in 1994, we get together in December at Organization Day and we take our oath of office to support the New Hampshire Constitution and the federal Constitution. And I'm sure I'd read the document, at least the U.S. Constitution, at least once in my life, but I thought that maybe since I'd taken this oath, I'd go back and reread it. I'd spend some time with the New Hampshire Constitution. And the amazing thing that I discovered when getting into the detail here is just how egalitarian the New Hampshire Constitution is. And it drew me into reading all the other constitutions of the other colonies. And when you do that, you get a perspective on this particular colony as opposed to all the others. And what you discover is, once you move from the constitutions to historical documents having to do with the origins, the founders, their thoughts, their interests in New Hampshire. When you look at the specific history of New Hampshire being the first state to actually fire a shot, the revolution really begins here, right? Before Concord and Lexington begins here 4 months earlier at William and Mary, the fort in Portsmouth, where all the powder was stored. They learned from Paul Revere that the Brits were coming up to confiscate the powder, and they gathered there in December. And I guess a shot or two were fired. If the revolution started, it started there. Why does this happen in New Hampshire? Why is this first colony to write a constitution? Albeit simple. The Congress encouraged all of the colonies to write their own. We couldn't hardly get out of the door to be first. We were first in many other ways. There were more men, for example, at Bunker Hill from New Hampshire than there were from Rhode Island, Massachusetts, or Connecticut. Stark showed up with 1,200 men from New Hampshire. That was kind of unusual when Massachusetts only had 9. Why is the fervor? Why is there so much fervor here? And when you begin to talk to folks and you read the documents of the age of the period, and you get a little familiar with New Hampshire history, you discover that New Hampshire, of course, is it was to the colonies as Maine is to the United States is today. It's way up in the northeast corner. It's a frontier. Its principal source of income is to some degree farming, but it's primarily a mercantile colony, the mercantile seafaring colony of Portsmouth that drives the economy. And a lot of folks bringing goods and materials in, probably illegally. So we're at the very end of the food chain, and so we're operating pretty much at our own will up here. And in addition, we discover when you read the historic documents that we've got this rogue governor, Benny Wentworth, who's using the colony as his own personal Ponzi, or I wouldn't say Ponzi is the wrong word. It's a generator for huge income on his part. He's been given in 1649, I think, the right to subdivide the state and to create all these towns. And when he creates a town, he keeps some 500 acres for himself. And so he's got a real interest in real estate development in New Hampshire. New Hampshire in the mid-18th century was like Florida was in the 50s, right? They're selling swamp and hillside and rocks and granite to these folks coming over from Europe who have money in their pocket, which incidentally is interesting as well, because if you look at the development in New England, as opposed to south of New York City, you'll find that people did come here with resources to acquire land. They were very interested in the rights of property. So you have this governor who's churning government in his own interest. People see that. Occasionally they run up against it. They find that he's giving benefits to his friends and so forth, and some of them, and the average folks are coming up on the short end. So you have this going on here, and then just south in Massachusetts, you have the British government, the British colonial government, kind of at its pinnacle. Massachusetts was a prominent mercantile colony. They had and at one point, of course, they're operating in the interests of the king. People look south of us, and they look at the corruption in Massachusetts. A system of government, and they see, for example, I think in 1760 or so, where the Supreme Court justice is a guy named Hutchinson, Thomas Hutchinson, and he's also the lieutenant governor. So under the colonial system, they were kind of commingling judicial interests and regular governmental interests, and so there's corruption pretty much everywhere, and all you have to do is read Sam Adams or any of the folks who are writing these fiery tabloid, fiery placards that were published to see just how we were being manipulated here. So
They were the bloggers of their day.
they were the bloggers of the day, sure. And so you find there's a terrific antipathy developing in New Hampshire against the crown, and so the origins, we had our own reasons for breaking with England. Anyway, the long and short of it is, not to get into all the detail, but if you read New Hampshire history and you discover the conflicts that the towns were having in terms of getting their own people elected to the legislature, the king could veto those that they chose. If you got elected, they didn't like Kevin, the king would say, "I'm sorry, you can't serve. You could elect somebody else from Nashua, but not you." So there were those kind of conflicts going on. So there was a lot of furor going over here, a lot of government interference in trade and so forth. So right out of the box, when you have an opportunity to revolt, we're right on the front lines. You ask yourself, why is that? So when you read the Constitution, you kind of get, the New Hampshire Constitution, you sort of get a clue. The first Constitution was pretty much pro forma, but the second one went before the people numerous times for approval. There were many Constitution conventions, and this is all during the course of the war, mind you. People are fighting down in New Jersey and New York and Carolinas and having this huge fracas going on. Up here, we're trying to figure out how to create a form of government while all this is going on. So you know that they were fairly dedicated. You read the Constitution and you discover something that's really quite remarkable, in that they don't create three separate branches of government in the way we understand it today. What they create is an all-powerful general court, an all-powerful legislature. The general court is called the legislature. The legislature is called the general court. They create virtually an all-powerful legislature. They create a very weak governor because they didn't want to replicate the excesses of Betty Wentworth. And they do what Representative Sorg said, is that they create a judiciary, but all the judiciary is an entity that adjudicates cases that come before them in relation to the law. It has no real power. And if you read the constitutional setup, basically, judges are appointed pretty much indefinitely to serve on good behavior. There's no limitation how long they can serve, except until they reach 70, they're supposed to retire. So they're there pretty much until the age of 70, provided that they act properly.
Who decides whether they act properly or not?
Now, that's what we get now. What you discover when you read the original documents is that all of that oversight is pretty much given to the legislature. And so the legislature just reviews to see that judges are operating independently, impartially. Of course, they're riding a circuit. They're looking to see that they're behaving properly, they're rendering decent decisions, and if they're not, there are two ways to remove them. One by a bill of address, which says, you're just not getting to court on time, you're not doing this, that, the other thing, you lose your commission. It's pretty much perfunctory. All the legislature has to do is get together with the government, governor, come to an agreement, and the judge is gone. The other way they provide for removing a judge is by impeachment, and that's only the case where a judge really commits a crime, malfeasance, that's four grounds for impeachment. But by and large, and also they give the legislature the full and complete power to create courts, to manufacture courts. All the courts in New Hampshire until about 1966 could be created or dissolved at will by the legislature.
So in theory, the legislature at this point, at will, it could dissolve a court.
Until 1976, every single court was subject to dissolution by the legislature.
Until then.
Yes, until 1966. That's Article 72A. Now, so, in the late 1800s, in the 1870s or 80s, somewhere in that period, there was a period where the courts were dissolved, recreated, dissolved, recreated, dissolved, recreated, and it created havoc within the judiciary, and it created an animus that political upheaval certainly created an animus with, I'm sure, members of the judiciary and lawyers and everybody else towards the legislature for this political upheaval that was going on. But it was they were unable to do anything about it because the Constitution provided those powers. And so things kind of died down after the late 1800s. The court kind of gets a hold of itself. We have a Supreme Court, we have these other courts, and things are moving along just fine. But you can see that probably the origins of an idea about how to get out from underneath the legislature's thumb began to work through justices and the judiciary in general. And so what you begin to see, if you want to understand how we moved from having a constitution which gave the people, through the legislature, complete 100% oversight over their judges, all you have to do is follow a series of amendments to the Constitution that occurred between about 1958 and about 1978. And you can see the subtle change. The judiciary is now working to get out of this situation where they have legislative oversight. The first thing they do is they do something that looks kind of innocuous. In '58, I think they change a word in one of the articles from Superior to Supreme Court. The legislature is given the opportunity to ask for an opinion on constitutionality of what it may or may not be, want to propose the one of laws. It can ask an opinion of the justices. Well, prior to 1958, you would ask the opinion of a Superior Court justice. In '58, the decision goes to the Supreme Court. And prior to that, I would presume if you could go to a Superior Court justice, you would get an opinion, but it wouldn't necessarily seem like it would be an opinion, but it wouldn't necessarily be as binding as an opinion you might get from a Supreme Court. But the subtle change that happens then, I don't know if that's the reason for it, but I suspect that's the reason for it. So they move this adjudicatory function to a higher level. It makes it harder to contest it. Then the real trouble starts. In '64, we have a Constitutional Convention, and someone must have, someone's done a thesis on the '64 convention, but a lot of bad things come out of the '64 convention. You can see that the judiciary has some horsepower, because two things come out of that convention. One is Article 72A, where instead of having these courts in New Hampshire that can be dissolved at will by the legislature, they create two constitutional courts, a Supreme Court and a Superior Court, which means that once there are constitutional courts, they can no longer be dissolved by the legislature. So they create their beachhead. They now have two courts that cannot be tinkered with. They become permanent. The next thing they do in '66 is they, see if I can find it. I had them both here. Oh yeah. What they do is, with respect to the bills of address, where you can just simply remove someone because you think they're a lousy administrator, what they now provide for is a means by which, if you want to remove somebody, let's say a judge in particular, this happens to be in the judicial section of the Constitution, but applies to all commissioned officers. Now you've got to create a hearing to allow that judge to have his day, more or less, in a legislative court, which makes it harder to throw the guy out. I tried to remove Justice Brock in 1999 through a bill of address. And it was amazing how the room filled up with his sycophants to come and say why he should not be removed from office for what I thought was improper judicial temperament. But in any event, so that's the other thing, to make it harder to remove a judge by address, where it had been very easy before. Then, what they do is in '78, the worst thing happens, which is the judiciary gets a constitutional convention to put on the ballot language which essentially removes the judiciary from legislative oversight pretty much altogether. 73A is what we're talking about today, and basically that says that the Chief Justice of the Supreme Court should be the administrative head of all the courts. He shall, with the concurrence of a majority of the Supreme Court justices, make rules governing the administration of all courts in the state and the practice and procedure to be followed by all such courts. The last sentence says the rules so promulgated shall have the force and effect of law. Now, once they did that, they're basically out of our jurisdiction. At the time, if you talk to people who were in the Constitutional Convention that created that opportunity, they'll tell you it was never their intention to remove the ability of the legislature to oversee the rules of the court. But what people have to understand, you have to remember, is Lord Acton's great admonition or great warning, which is he says power corrupts, and absolute power corrupts absolutely. And if you give any institution of government, whether it's the legislature or the governor or the courts, the opportunity to exercise power, that institution or individual or body will eventually find some way to exercise all the possible power that they can aggrandize into themselves. And so where this proposal to provide the courts with this administrative ability, the power to kind of coordinate all the courts, to get them all operating the same way, people never thought that they would turn into an independent fiefdom. And so what we've discovered over time, since 1978, is that the court, in fact, is slowly distanced itself from public oversight. And the result of that has been, what happens then is a mindset begins to grow. This mindset begins to develop. The court begins to see itself as independent, and it's human nature. If you're given that thought, then you're going to exercise it. And what's going on concurrently with all of this is a change in the way the judiciary thinks about itself in the administrative justice, and it began to become imbued with the idea that the courts ought to administer therapeutic justice instead of just simply ruling on the laws that the legislature makes. They begin to get the idea that the courts are there to do what the legislature will not do, which means that when they get cases that give them the opportunity to resolve some kind of social ill they may feel exists out in society, they will take that case and they will use it to advance a social agenda or a political agenda or something of that nature. And so two things happen. You have a court now that begins to develop the idea it has this authority, it can affect social change, it's free of oversight, and can do what it wants. And I think that particular attitude that grows through these periods that we're talking about develops Claremont 1, which is really a blatant attempt to force income tax upon the people, to pay for education, and it forces Claremont 2, which is just simply an amplification that the state has to pay for everything. And you begin to see decisions which don't seem to have any foundation whatsoever in the Constitution. They have foundation in something else, which is the minds and hearts of the judges.
Which brings me to the next segue, redress of grievance. When the courts are a power unto themselves and the people have no recourse because of the weakened legislature, they find themselves before a court that may have a deaf ear, and so then the people come to the redress of grievance committee at some point because of the apparent abuses of this court.
Well, we had no redress of grievance committee as Paul Ingbretson and you perhaps mentioned earlier, but until this session, until the formation of the redress of grievance committee, you could present a petition to the legislature, but it would just be put in a file someplace. Once upon a time, I looked at a lot of the original petitions that were made after 1784. It's very interesting. They petitioned the governor for all sorts of stuff. bridges, back pay of colonial soldiers, you name it, the appointment of friends or relatives to political positions. There's all kinds of, it's fascinating to read that stuff. And at that time, you had a legislature that, remember, it was responsive. The 400-person legislature is not an accident. When I mentioned it was egalitarian, they created a legislature where all you had to do was have 100 male taxpayers in your community, and you got a rep in the House. And that process of providing people representation with a big legislature went until 1943 when they outgrew Representatives Hall and being cheap. And rather than build a new building, instead of building a new building to accommodate this larger, ever-growing legislature, what they did was...
That's why we have tiny seats.
Yeah. What they did was they said, wait, we can't go have a legislature bigger than we can accommodate in this room, so they set it at 400 as a max and 375 as a minimum. But when you look at the House is a reflection of how the founders felt their government, where the underlying power ought to be, which is with the towns. The towns elect their representatives. They come to the legislature to resolve issues in their interest, and it's supposed to be a government by the people. There is nothing like it anywhere in the world than what we have in New Hampshire. And so when we have a court now that's pulled itself away from public oversight, it's acting in contravention with the underlying precedents that we considered in founding this particular colony, this particular state, this independent state. So it's created a real anomalous. Well, that's the wrong word. It's created a real conflict for us, because you can't have a court operating that independently. I said to someone the other day, the New Hampshire Supreme Court is to New Hampshire as Romania is to the U.S. Congress in a sense. In that the U.S. Congress can send Romania money, but you don't have anything to do with their government or operations or anything else. And our court is so remote that it really has that same kind of relationship. Just a couple years ago, in 2005, they created an entire independent branch of government on their own, without any oversight from anyone, which was the Administrative Office of the Court. It was a single public hearing. There was no discussion about staffing or anything else. They just created it. As a legislator, prior to 2005, I entered a couple of bills to create an independent office of the court. So we would have an independent office that would operate similarly to the Office of the Court, the independent office in Congress, which would deal with all the nuts and bolts of keeping the system running. The justices in Washington don't get involved with the nuts and bolts. But up here, you appoint a justice. We just appointed a new justice, a guy named Jim Bassett. We appoint him because ostensibly he has some kind of particular qualifications to be that sort of a judge, and to look at our laws and to rule fairly. And suddenly he becomes an administrator of the court system. I don't think people think about judicial appointments as being somehow CEOs of corporations. Because if you're looking for that sort of skill, you ought to be looking somewhere probably other than with the judges. So anyway, so what we've done with 73 is created this entirely different take on the courts than existed in the minds of anybody in 1784 or 1792, when the Constitution was first adopted and then substantially rewritten and fixed up in 92. So that's where we are today. We have a Constitution which says that the people are in control. It's our government. We have lots of representatives. We have a very weak governor for good reason, because of Benning Wentworth. We don't give that guy any power at all.
And we have an executive branch to keep him in check.
And we have, well, the executive branch, I mean, we have the executive council to keep him in check, right? So he has really very little room to do anything except to veto bills. And we had a court that was entirely under the purview of the legislation. Now we have this court that's over here. We have the rest of government over here. And we're in a very difficult situation, and the Claremont decisions are a good example of what happens when you allow this sort of transition to occur.
Well, we're going to take a quick break, and we're going to end up with Representative Ingbretson. And we're back with our roundtable discussion on 73A, and I want to now that we've gone through some of the historical facts and of course a number of topics. it seems to me that the pinnacle, in my perspective, is this whole idea of the Redress of Grievance Committee, because I do sit on that committee, and I am sitting next to my chairman, Representative Paul Ingbretson, who has to rein me in from time to time. I do get a little heated and I'll publicly apologize for that later. So you have the floor right now, and if you could talk about the history of it and the origins and what it's all about.
I'd be glad to, and thank you for the opportunity, Representative Avard. And by the way, for anybody who doesn't know, Representative Avard was responsible for that fantastic press conference just a few weeks ago, if you heard it.
Thanks.
He deserves all the credit, even though he didn't get to show up.
Well, that's all right.
So thank you for that. And I wanted to say this because I think it's important to say that I don't think that very many people realize, Representative Avard, how crucial this group of 3 people, at least right here, is to where we're trying to get back to, and how the work that they've done to get the root knowledge back to us and all that sort of thing. And as I said, you and I probably feel like we're just picking up the pieces, and actually playing out a role that's more practical.
Right.
And so what we're doing is, and Representative Itse can give us more history in a minute, but what we're doing is we're finding, and we found out a number of years ago, there's any number of people out there who are feeling really seriously abused in our judicial and the family division in particular, having to do with divorces and that sort of thing. And we're finding incredible anomalies that look like they're related to 73A, to the idea that the courts can control the practices and procedures and make rules that are effectively law. And as you know, because you've referred to it any number of times, in fact, you were very instrumental in getting us to propose, or in one of your bills, trying to get us to propose a change to 73A, which is what's coming forward shortly before the voters. There's that famous rule right at the beginning of the family division's set of rules, and it says that it's Rule 1.2, the famous Rule 1.2, that says that they can waive any rules.
For good cause.
Well, they're supposed to even explain it, right? So for good cause with an explanation. But if you can do that, you don't even have to give an explanation because you can waive that rule too. So it's one of the more marvelous things I've ever seen, actually. But what it tells you, these people are crappy legislators, because no legislature would be that arrogant or foolish to give some of their underlings the power not only to waive whatever rules, but to also would include waiving the rule that they have to explain why they did it. Exactly. And so, but that's precisely what we're seeing, and it's causing these incredible problems. In one case, we heard about 500, as you saw, 500 motions.
Oh, yes.
In a matter of just a few years. Another case, 300 motions. It's an ungodly thing. And the kinds of stuff we're hearing about are failures of denials of due process. And most of the people coming to us, and now, look, we have about 27 or 28 redress of grievance petitions in front of us. Most of them are from the family division. They include the GALs, a bunch of GALs which are separated, some of them in those bills, and some other places, the guardian ad litem's, right, which are functionaries of the courts. So the bigger part of our work is actually coming directly from these courts. DCYF and others even are involved in the family division, and not necessarily all the time, the superior courts and others. Superior Court is that particular. I probably have to ask Representative Itse if that's also where they go. He's from that.
If I may interject just one other thing, that the Supreme Court just handed down a ruling giving the guardian ad litem's full immunity?
Yes, yeah, and that's one of the more remarkable things, and it looks like it's coming directly out of our, we have had, this follows within 2 weeks, I believe, of our looking for subpoena powers. And I had one of these most astonishing letters, one of the kinds that only lawyers can write, a vicious letter to me, telling me I had no power. I can't do anything with regard to GALs. And then 2 weeks later, not after that, I received that letter, well, several months in advance of this. And he's telling me I can't have this person in there, and I can't even talk about them because they're private contracts and all that sort of thing. And it's just not true. But in the meantime, the court has now, through some motion or other, I don't know how that all works, that they got in there, but all of a sudden they're declaring that the GALs are immune. And one of the more fascinating things that a court can do, actually, is make anybody immune from the people themselves. I mean, this is where the most staggering things in government.
They keep insulating themselves from the people.
Well, isn't that what you would do if you had the power to make whatever law you chose to make,
right,
as Representative Mirski points out? So we're looking at these repeated, and people saying this, repeated failures of due process, the right to have your side heard all the way, and to present your documents and to present your witnesses and to all this sort of thing. And they all do it in the name of, well, you have to have a court that's more loosey-goosey when you're dealing with family issues. Because, I mean, and all it's done, the process has produced this sense of injustice, and an incredible sense of injustice. You know, I mean, there were 9 or 10 people were involved in trying to impeach just one marital master, Cross, which we haven't been able to succeed at doing. But those people all stood down and didn't get involved in the redress of grievance process, or we would have had 20 or 30 people coming before us. And by the way, another evidence that there's a significant problem in the courts is that a gentleman, Thomas Ball, the Ball family has a long history of involvement in the Revolution and the establishing of liberty in our state and in New England. And here's this guy burning himself on the steps of the family court in Keene just last year. And it's an astonishing thing to me, and where's the conversation about it? But that's a different story. But that's directly related to the custody of his own kids. He can't even see his own kids, and he can't get out of it because they've created such amazing stipulations regarding what he has to pay and what he can pay and what he can't pay, and he can't even get there from here. And we're seeing this over and over again. Now, in the course of one hearing, the word that came up among several of us was the word arbitrary. I actually asked the person, you know, what word would you use to describe what you're seeing? And I said, would the word random apply? And they said, yes, that's exactly. We can't figure rhyme or reason. And so we're finding people are pulling out of the system, and they become problems to themselves, to their kids, to their family members, and of course to the courts, because they're seeing that there's no rhyme and there's no reason. It's just whatever. And so we're dealing with arbitrary law, the very definition of which is tyranny. And that's what the courts are doing under their auspices of their own rules and guidelines and so on. So that's the bottom line. And what I and I don't need to be really long on this because I know you want room for other conversation, but you know yourself how many other things we've dealt with. But due process, I mean, we're finding that judges are actually breaking our statutes, that they're allowing GALs to break our statutes. This is statutory problems. We have, I mean, I've got 4 pages of things that I've just broken out by topic and not even tried to explain, but very significant abuses of discretion and power, significant best interest of the child abuses, and they're just going on and on. And it goes on. The word random is probably the key word. I think I can end quickly my conversation here with this. I want to actually read, before I end it, though, I'll read afterwards. I'm an artist, and the fundamental thing is beauty, right? And the word beauty is so important. The word aesthetics and all that sort of thing applies, right? So we're looking at the most wonderful thing that's happened to mankind in the representative government. You know, we're not dominated by one guy or his little clique or his class. We've finally gotten to a place in New Hampshire more than any other place because of the provision of redress of grievances, more amazingly there than any other place. So we have this remarkable, what I call beauty in the sense of the way of a form of government that protects liberty. More than any others, we have it. And it's in these 2 provisions in Articles 31 and 2, and anybody who hasn't got a Constitution of New Hampshire should have it just for the enjoyment of reading the nature of, of a government formed on the basis of liberty. Right. But Article 1 requires the legislature, it says the legislature shall assemble for the redress of public grievances and for making such laws as the public good may require. It says they shall. That's not a choice we have. That's Article 31, but there's 2 articles actually in our rights portion. The second one says the people have a right, in an orderly and peaceable manner, to assemble and consult upon the common good, give instructions to representatives, and at request of the legislative body, by way of petition, a remonstrance, redress of the wrongs done them and of the grievances they suffer. And this is specifically to do with government offending you and injuring you and damaging you and taking away your property, taking away your rights, taking away your income, whatever it is. So you have this built in. They have the right, we have the obligation. And redress means fix. Now, before Merrill versus Sherburne, and all the experts here can talk much better about that, but before Merrill versus Sherburne, we were sending things back to the courts and saying, "What kind of crap is this?" Excuse my expression.
Right. No, that's fine.
And they were dealing with it. They would fix some things, and there's no end to the numbers of things. But what we've dealt with, as you know, is issues regarding tax assessments, issues and one. To show the effect of what we've had, one town, when they heard that the person was planning to come to redress, quickly got on board because there was a selectman there who communicated this to us. they quickly got on board and said, let's fix this real quick.
Yes, and they did.
Because who wants to be dragged before
Right.
us, right? And so we've seen where a town had 9 years worth of no minutes,
Right.
and they came before us in this very lawyerly way and said, well, but we won't do it anymore.
Right.
You know? But in the meantime, you know, there's this big worry that another town will say, oh, they did 9 years without minutes, and they come before us and they beg to have this mercy, and we actually are looking to make it punitive now. We're trying to we're recommending a law so that if you do the without minutes, then there would be a significant fine to the individual and to the town. So in that direction, so you know what sorts of things we're talking about, but what we want to get to is responsible government. So the purpose of us managing it as the people is so that we protect ourselves.
Right.
And there has to be this last recourse where we get back and we say, all right, and now, how have we hurt you?
Right.
And what we've done.
And I've heard you say that to many of the people that have come before the committee. Do you feel as though you've been heard?
Right.
And I think that this whole committee, in my opinion, is a beacon for many citizens in New Hampshire. And once we get I mean, it's brand new, and it's kind of in its infancy, and we've had some growing pains that have gone with it, but...
You should let Itse give you the history of,
Yeah.
you know, don't you want us to give some further history of redress? It'd be worthy.
I would like to open up this up to a roundtable discussion. I do want to bring one thing to mind, though. It is you, Representative Mirski, that brought forth the bill, CACR 26, to repeal 73A as is,
Yeah.
bringing the power from the courts back to the people so that the people have a voice.
Right.
It passed the House by a 2/3 majority.
Right.
It went to the Senate. And now the Senate had some type of dialogue with the Supreme Court, and now there is some kind of a machination of whatever. Instead of it being fully repealed, it is somewhat modified to benefit the people to some degree, because now the people have somewhat of a voice, but it's still not perfect.
No, look,
And this is up for
just to touch on that briefly, I filed that bill kind of late. I wasn't even going to do it for a while initially, but I thought, well, with this majority, maybe we have a shot. We've tried on 2 previous occasions to amend 73A, and both of them failed, first in the legislature, and I think maybe in the Senate. The second time, we modified the language of 73A to give more legislative oversight, and the courts intervened on the very last week of October, to prevent the publication of a voter's guide that would explain why the legislature thought that this should be passed. So the court directly intervened in the legislative process to prevent the people from getting a picture and understanding of why why the last constitutional amendment should be considered favorably. So this time around, I thought, well, if they did it the last time, why not just repeal the whole damn thing?
Right.
We'll go right back to the way it used to be. And quite frankly, I happen to think that's, in the long run, the right solution. However, possibly, as we were talking about in the car on the way down, because this redistricting committee has been created, is now looking at all these issues in the court. Maybe it is true, as Representative Itse suggested on the way down, that the court decided maybe this time they ought to come in constructively. And they came to us with a proposal which essentially creates an opportunity for the legislature to review court rules and vice versa, so that there will be oversight over these rules in the future, and the legislature will be able to touch on them. And I think that, although it's not what I would like to maybe have put before the people, this amendment is certainly a step in the right direction, and it will create a dynamic between the court and the legislature which will become public. And we'll have debates about exactly what you're concerned about right here,
right.
Public debates, and then the people will be able to get more and more informed about their court.
So this begs a question. As it stands right now with the, and I just wanted to applaud you on that and give you the due credit that it was due, because that was a monumental thing for you to bring.
It's kind of a big deal, I think, that it's now got through. We're going to have something on the ballot. I just want to make one other thing. It's kind of a sidebar, but it's important for your listeners, anybody who discusses the Constitution, to understand something. This Constitution we have in New Hampshire is unlike any other in this sense. It starts with a Bill of Rights. Before the founders get around to talking about government, they say, we have this right, this right, this right, this right, this right. There are 38 or 9 of them in the first part of the Constitution. They say these are the bundle of rights that we believe we have in essence. both internally and constitutionally. And only after they establish that, what it is, it's a social contract. Only after they establish that do they get around to saying how government's supposed to work. And so all these these articles in Part 2, which talk about the legislature, the Senate, the council, and everything else, the judiciary, it's with the understanding that all these things in the first part apply universally through all the agencies and other branches and other chambers of government. So understand that we have a unique, we have this unique Constitution, and that's, as I said earlier, that's egalitarian. It starts with rights, and that's what we're talking about here, is we're talking about trying to bring the court back into influence.
I know Representative Itse wants to say
yeah.
one thing, but before I do, I wanted to ask, I wanted to bring one other thing out. We have this redress of grievance committee that was appointed by Speaker O'Brien. This was a courageous thing to do.
Very
it was
courageous.
very insightful, and I want to give him kudos on it.
Absolutely.
And I want to publicly endorse him for being the speaker next time around, because I really think that he's the only one that I know of that supports this committee. And so I'm going to move right from on to there to Representative Itse, who seems like he wants to get out of the game.
I'm chomping at the bit. One, I wanted the history of our Constitution. We had the first written Constitution, actually, I think probably in the world, after we had ousted Governor Wentworth by rolling a cannon up to his front door to demand he turn over a militia officer. He decided it probably wasn't good to stay here.
He went out the back door, by the way.
He went out the back door
to his boat.
in July. Well, he actually retreated to Fort William and Mary. And by the December of '75, our provisional legislature said, you know, my God, we don't have a form of government. So they created something that wasn't too awfully different from what they had to begin with. They had a House of Representatives, an executive council elected by from that House, which formed the upper body. The president of that council was the president or the chief executive of the state, and he was also the chief justice of the court. So they had this very unitary government. But it was intended to be only temporary. One of the primary motivations for that was not having executive courts available to punish evildoers. By '79, they decided, well, we really got the other colonies after the Declaration of Independence. We did ours in January before the Declaration. They created their own constitutions, and we looked at them and they said, you know, a lot of those are really kind of better. So they put forth a very abbreviated Bill of Rights, about 7 or 8 articles, and basically reproposed the provisional government that had been put in place by the then legislature. And the people said no, and they rejected it, and they came up with something that looked very much like our current government, and the people said no to that. It was way too radical, and they created a government that had a House, a Senate, the president, a president of the Senate elected by the people at large, who was also a voting senator. And the Executive Council was elected by the legislature in joint session, comprised of 3 representatives and 2 senators. And then it all pretty well looked like what we have now. So the people rejected twice, and we're the only jurisdiction that has ever rejected a constitution. We did it twice and then accepted the third one. So now that's 1784. We puddle along for the next 35 years. During those first 35 years, the most frequent activity of the legislature, almost all legislation was introduced by petition.
That's right.
Is that right?
And the majority of those petitions were against the judiciary. You get to 1816 and 1818, which is 2 elections apart because they were annual elections. And in 1816, the Republican Democrats oust the Federalists, and then 1818, the Federalists re-oust the Republican Democrats. And each time they reconstituted the judicatories of the state, top to bottom. So now, by the time you get to 1819, you have virtually no institutional memory, and that's when Merrill versus Sherburne is adjudicated.
I'm curious, if I may interrupt you.
And
wanna get to the
what Merrill
petition.
versus Sherburne does is the judiciary says, separation of powers, legislature, you don't have the power to receive petitions in regard to us. So they unilaterally exempted themselves from legislative oversight.
The Constitution itself.
And so because that was now out of their petitions for redress, fall into the dustbin of history, completely lost by the first part of the 20th century. Roll around 2006 and we have a controversy with the court telling us that we can't put names on the ballot in alphabetical order. And we actually got a special session of the House and Senate based on some arguments on Part 1, Article 29. And at the conclusion of that, Representative Mirski says to me, because of my arguments, he says, you really need to go and write a commentary on the Constitution of New Hampshire, which forced me to go through. I mean, you got to think of something to say about every article, right? So I read through every article and try to think of something to say. In the middle of that, I find Articles 31 and 32. And I'm sitting there going, oh my God, look at this power that the people have. So in 2007, I tried to introduce a petition for redress and found myself totally rebuffed, that there was no power to do it. The nuts and bolts were no longer there. Mm-hmm. So in 2008, I tried to introduce nuts and bolts, and the then legislature refuses it. And then in 2010, we get the beginnings that at least the petitions get read into the House and put in the file drawer. And we created, all the individuals here, I think, sat at one time on the ad hoc committee for redress of grievances, including now Speaker O'Brien. Yes. And that was why he saw the value, because he started to see the injury of the people by the government. And that's what redress of grievances is all about, is to give the people their venue.
I'm going to have to wrap this up real quick. So what I guess I'm going to, number one, thank you all very much for coming on to the show and talking about...
It's all your fault.
Well, no, everybody was...
No, his fault.
This is all good.
That's all right.
I think I could listen to you for a lot longer. 73A, CACR 26 is before the Senate, and it should be on the ballot. Do you recommend that the people vote for this?
I do, yeah.
Yeah.
I do.
Are we all,
Oh, yes.
all in agreement?
We are all in concurrence, and the Senate has, well, the Senate adopted the compromise proposed by Judge Lynn. The House has put forth a position of concurrence. So it...
And by the way,
Will be
the
on the
proposal that Lynn made to the committee was with the concurrence of the other all the justices of the court. So the court is theoretically entirely behind this language.
Okay.
And so I don't see them intervening to try to prevent passage as they did in 2004, I guess it was.
I mean, we won't see full-page articles in the New Hampshire Bar News advocating killing it, like we
Right.
did in 2004.
So it's a step. Anytime. Government takes a long time. I tell people it took Sam Adams 16 years to get control of the Boston caucus, right? Then he turned the world upside down. You have to accept you have a long horizon in all of these things.
And the proposal by Judge Lynn is almost, except that it's actually better than the proposal they worked to defeat in 2004.
Yeah, that's true.
Yes.
And gentlemen, on that note, I'm going to have to say thank you very much for coming on Speak Up. I would love to have you on again at some future time to talk about some other topics. And I want to thank my listeners and viewers for joining us. And if you like this discussion or topics like this and you want to be considered a person who sponsors a show like this, we welcome that. And you can contact us at speakupnh@gmail.com. Until next week, we'll see you. Well, as you can see, we have a very important topic with CACR 26, Article 73A, the balance of power with the courts and with the legislature. Remember that the legislature is your voice. It's your voice. CACR 26 is an important piece of legislation to get back the balance of power. If you enjoy Speak Up, we invite you to be partaking of it. If you want to come on the show, give us a call or email us at speakupnh@gmail.com. And if you want to support the show, please become a sponsor. You know how to get in touch with us. Until next week, thank you for joining us.